Welcome to Business Better, a podcast designed to help businesses navigate the new normal. I'm your host, Steve Burkhart. After a long career at global consumer products company BIC, where I served as Vice President of Administration, General Counsel, and Secretary, I'm now of counsel in the litigation department at Ballard, a law firm with clients across industries and throughout the country. Today's episode features a discussion on cryptocurrency. What is cryptocurrency, and what are the rules that apply to this increasingly popular but complicated financial instrument? For those seeking to be in the business of exchanging crypto, what registrations and compliance programs are necessary to meet regulatory requirements? How should crypto exchangers and other financial institutions address crypto transactions involving unhosted digital wallets or requirements that counterparties in certain crypto transactions be identified and reported? Today, our Ballard team will help answer these complex questions and explain why it's important to seek counsel before transacting business in cryptocurrency. Participating in this discussion are Mike Robotti and Marjorie Peerce, both of whom are partners in Ballard's New York office, and Peter Hardy, a partner in Ballard's Philadelphia office. Mike, Margie, and Peter all focus on representing the white-collar defense and internal investigations practice. Now let's turn the episode over to Mike to kick off the discussion with Peter and Margie.
Thank you, Peter Hardy and Margie Peerce, for joining me today. Before we get started, can you tell our listeners where they can find more information once they finish listening to today's discussion?
Thanks, Mike. Happy to chat about that. And I just want to say thank you to everyone who has tuned in to listen to our podcast. So I can never resist giving a shout out to our blog, Money Laundering Watch. If you're interested in these issues, we certainly cover crypto. We cover all things money laundering and anti-money laundering. Please check out Money Laundering Watch, Ballard Spar's blog. I'm a little biased, but it's a really good blog. And if you're interested in these issues, I think you'll find it useful.
And I can ditto that it's a really great blog that Peter started. But what I want to just say is at Ballard, about 4 years ago, several of us recognized that crypto and blockchain were going to be very important areas that were going to require legal services. And so we formed a crypto blockchain group, and we have lawyers from almost every discipline in the firm who are part of our group: intellectual property, consumer financial services, white-collar criminal defense, securities, you name it, we've got it, corporate work. NFTs are now out there. I'm sure we're going to start having clients that want to do something in the metaverse. And so we offer you one-stop shopping for work on your crypto matters.
So Peter, why don't you kick off our discussion here today? What are some of the U.S. regulatory challenges facing cryptocurrency exchanges? In particular, what are the Bank Secrecy Act and anti-money laundering concerns?
So there's a couple of parts to that question. And I guess I'm just going to start off very high level at first and keep it very brief. So, the basics are, if you're a crypto exchange, then chances are that FinCEN, the Financial Crimes Enforcement Network, which is the regulator for the Bank Secrecy Act, is going to regard you as either a, quote, exchange or an administrator. And the translation is, what that means is that you are most likely going to be a money services business and therefore covered by the Bank Secrecy Act, and or a money transmitter under various state laws. I'll get to the state laws in a second. So what does that mean? Well, what it means is that you have to register as a MSB, money services business, with FinCEN. That's relatively easy, but it also means that then, because you're covered by the BSA, you've got to have an actual anti-money laundering program and all that entails. Compliance officer, independent testing, training, customer due diligence, et cetera, et cetera. So it's the day-to-day onus that can be difficult under the BSA in terms of running a functional program. Now, under the states, the state's kind of a patchwork quilt, and in many states, if you are an exchanger or an administrator, you do have to then obtain a money transmitter license, and that has its own set of obligations and regulations. Other states, they take the position that crypto doesn't count as money or funds or whatever the magic word is under their state statute. So those are the basics. Now, in practice, and I'll use an example just to kind of illustrate it, typically the enforcement cases, whether criminal or regulatory under the Bank Secrecy Act, have all kind of centered around a failure or an alleged failure to register properly as an MSB or a money transmitter. Now, the Department of Justice charged some individual executives at an exchange, very large exchange called BitMEX. And, one of the interesting things about that prosecution is it actually wasn't based on a failure to register as an MSB. So it is a exception to the kind of general rule that I just noted. Rather, is a little more esoteric. And they were considered by the government, BitMEX here, to be a financial institution covered by the Bank Secrecy Act because they were future commission merchants, which is a little unusual, but regardless, that was the position of the government. And those prosecutions are still pending. The gentlemen are as of now, at least, going to trial. And the allegation there is that they utterly failed to maintain the AML program that I just described. They're based in the Seychelles Islands. And there's another facet to that case that really is a constant theme in a lot of the enforcement actions that we see, which is a exchange or a business that is, according to the government, not properly registered in the United States, supposedly operating abroad only, but they have U.S. customers, which, of course, in the crypto world is very easy to happen. And so that's the jurisdictional hook and also part of the allegations of regulatory violations and criminality. And then just to follow up on that, FinCEN, along with the CFTC, settled a regulatory enforcement action with BitMEX itself, the organization, versus the gentlemen who have been prosecuted. And the outcome of that was a $100 million fine and a commitment to file suspicious activity reports that had not yet been filed. You have to hire an independent consultant who then needs to help them ensure that, in fact, they don't have any U.S. customers. And what happened there is something that happens with regularity, is that the U.S. customers were using something called a VPN, which is a virtual private network, which then masks or usually masks your location. And the government allegation is that nonetheless, BitMEX still knew that the folks that they were dealing with included U.S. citizens. So that's kind of a very high-level description of some of the core regulatory and criminal risks that folks can face if you're in an exchange. And I want to just switch gears slightly and then kind of move on to some more pure regulatory things that have gone on lately. Let's say that you have your functional AML program and you're properly licensed in the U.S. and you're doing everything you should. There's a couple of things coming down the pike that you still need to be aware of that could definitely affect you in terms of compliance costs and efforts of that nature. So one, to be a master of the obvious, the government's very interested in crypto right now. On the AML front, there's a big new law that was passed earlier this year, the Anti-Money Laundering Act. So it defines a money transmitter subject to the BSA as a business engaged in the exchange or transmission of value that substitutes for currency, i.e. crypto. This pretty much just formalizes the longstanding position of FinCEN that I already described. So that's one. The other thing is FinCEN came out as required by Congress this year with a list of anti-money laundering national priorities. Crypto itself was not included in the list of 8 priorities, but it definitely got a shout out. And according to FinCEN, it's the, quote, currency of preference in a wide variety of online and illicit activities. And on that note, FinCEN this year created for the first time the position of Chief Digital Currency Advisor. So the point here is there's a lot of things that are converging, and the government is definitely taking a coordinated or semi-coordinated approach to regulation. There's two possible regulations out there that I think are worthy of noting. And this will also apply to banks and other financial institutions as well. So FinCEN proposed a new rule for, quote, unhosted virtual currency wallets. So an unhosted wallet is one that's not provided by a financial institution or other service, and it basically resides on a user's personal device or offline. So for transactions involving an unhosted wallet, and this kind of gets into, a lot of the unique practical problems that crypto can pose for financial institutions, whether they be exchanges or otherwise, who are trying to comply with these rules, because AML is all about transparency and identifying the true identity of your customer. So for transaction greater than $10,000, the proposed rule, and it's still proposed, it hasn't been passed, would require banks and money services businesses to submit a report to FinCEN, analogous to existing reports for currency like a CTR. And so you'd have to have the full name and physical address of the client, the name and physical address, and this can get tricky as a practical matter, of each counterparty to the transaction, the amount and type of virtual currency being transacted, the assessed value, and all other information that basically uniquely identifies the transaction, the accounts, and the parties involved. And it's really the requirement for the counterparty that gets very tricky, because, and this bleeds into the second proposal that I wanted to talk about. Again, FinCEN proposed that the travel rule, which is an existing rule under the Bank Secrecy Act that already applies to banks, be greatly expanded. Travel rule, essentially, to dumb it down, the information travels with the transaction. So again, if you are a financial institution that is on the originating side of a transaction, you need to know who is the counterparty who's on the recipient side. So it would expand the travel rule to reduce the current $3,000 threshold to only $250 for international transfers, thereby greatly expanding it. And importantly, it would explicitly apply to transactions involving virtual currencies. So this is a bit of a challenge, largely because of technology. I mean, the technology is being worked out, but, unlike for traditional fiat transactions, there's no SWIFT system in place. SWIFT is the system that financial institutions use around the world to track counterparties and things of that nature. There is no system in place for crypto. It's a particular problem if you're talking about DeFi or decentralized finance, where government may not agree with this, but there's no one there. There's no one running the system. Having said all that, the Financial Action Task Force, which is an anti-money laundering body based in Europe that provides standards for participating countries around the world, has long had the travel rule in place for virtual currency transactions over $1,000. So they're already there, although they actually concede that there's no technically proven means of identifying a virtual currency provider that manages beneficiary wallets. So they concede that, but they plunge ahead anyway. And, the OCC is examining banks for the travel rule. The IRS is examining crypto exchanges for the travel rule and other requirements. So it's out there. And, just to bring it home, and then I'll stop talking. The BitMEX enforcement action that I referenced, the one that was recently resolved, had some language in there expressing, FinCEN's expectation as a practical matter as to how virtual currency exchanges can indeed, through various means, not necessarily easy, but they can find out information about past transactions and counterparties by using various address clustering tools. So, that's a long-winded way of answering your question, Mike. The upshot is we've got the basics, the core BSA requirements. Government is definitely active in this area. And, beyond just the basics, there's some more onerous and more esoteric regulations that are potentially down the pike.
So just to follow up on that, what about the U.S. criminal money laundering statutes? What are the particular concerns there?
Yeah, so, let's not forget of the constant existence of the criminal code. And so that's Title 18, and here it's sections 1956 and 1957. Those are the good old-fashioned standard money laundering statutes. And, anyone who is going to be involved in crypto on the business side and, frankly, fiat currency needs to always remember, regardless of FinCEN and the SEC and the regulators, there's always the prosecutors and the possibility that if that's the key, if you have the mental state to know that a transaction involves so-called dirty money, then without getting into all the other elements of the statute, you could definitely be assisting or conducting a money laundering transaction. And especially with some of the practical problems of determining who you're dealing with. And it also always gets down to the constant question in AML and money laundering in general, which is source of funds. It always behooves folks to remember, beyond just regulatory requirements, there is just that, and this applies to everyone, don't have to be covered by the BSA. You can be a real estate agent or whoever. You always got to worry about the Title 18. And, when things first started, that's what the government was using. When you think about Silk Road prosecution, which was essentially an alleged drug, gun, and child porn bazaar, that's, they charged drug charges and they charged money laundering. The industry obviously has greatly matured. There's still some bad folks out there, but obviously virtual currency is light years from those days. And so, now we're really seeing more regulatory action. But again, the criminal code is always there. And there's kind of an armchair debate about, is fiat currency worse or is crypto worse in terms of the amount of dirty money or dirty funds that's being transacted? It's hard to say, and part of it depends on whether or not you're talking about investment transactions or transactions to acquire, what have you. There's a lot of folks that say that fiat is still, the method of choice for money launderers. And in terms of just raw numbers, that's probably true. But again, issues with knowing who the counterparty is and source of funds, it's a particular issue for crypto.
So let's focus for a minute on traditional financial institutions. What should they be thinking about if they are considering doing business with crypto?
Yeah, so I guess it depends on the customer. If you're thinking about dealing with an exchange, because at the end of the day, these exchanges need access, or many of them, to and desire access to the traditional banking system. Is your exchange properly licensed? Again, the state money transmitter laws can be difficult because they're just all over the place and there's a lot of vagueness. And what are their own AML processes like? That's part of if I'm a bank thinking about banking a crypto exchange, and many banks really don't want to do it, but there's some out there who are willing, to kind of take that on those extra compliance costs. You need to dig into the functionality of their own AML processes. If you're talking about individual customers, make sure that they're actually not functioning as a money transmitter. Maybe they are, even if it's just a person, they could still be a, quote, exchanger or administrator. And again, we get to the source of funds issue. I just want to wrap up. I think, the really interesting thing now is traditional financial institutions that are themselves thinking about getting into crypto and the blockchain. And again, we get back to the regulators, and there's been a lot of movement on this recently. So the FDIC earlier in 2021 sent out a request for information on the role of banks in crypto. And those responses came in over the summer. And then partly based on that, but some other activity as well, the FDIC, along with the Federal Reserve and the Office of the Comptroller of Currency, issued in November a short joint statement on crypto asset policy. And they purported to produce a roadmap. Short story short, the policy statement itself really provides no concrete details. It really says in 2022, more clarity is forthcoming, which obviously would be, very appreciated. The roadmap has 5 bullet points, and these are the activities that the federal regulators are going to supposedly provide more clarity on in 2022 for banks that are thinking about getting into this. And a lot of this is, there's an AML component, but a lot of this is just kind of straight up bank permissibility issues. So crypto asset safekeeping, ancillary custody services, facilitation of customer purchases and sales of crypto assets, issuance and distribution of stablecoins, and the holding of crypto assets on a balance sheet. So these are all things that banks are thinking about or starting to get into. And obviously, the regulators are taking a, shall we say, cautious approach. They call it a sprint. I'm not sure that industry would agree with the use of the word sprint. And then at about the same time that this joint statement was issued, the OCC issued an interpretive letter, letter 1179. And the upshot of 1179 is that on one hand, it validated and confirmed some prior interpretive letters by the OCC, which basically said the following. If you're a bank and if we examine you, the following activities are not categorically impermissible, so long as you have sufficient processes in place. They covered a lot of the activities that I just ticked off that were on the roadmap. So as whether or not you can provide cryptocurrency custody services. This was interpretive letter 1170. So the more recent letter confirmed that. And there was also whether or not you can hold dollar deposits serving as reserves, backing stablecoins. That was letter 1172. So the more recent letter confirmed that too. And then finally, we've got letter 1174, which addressed whether banks can act as nodes. So we're really starting to kind of get out there on the blockchain, independent node verification network, and whether or not banks can engage in stablecoin activities. So the upshot is that in this more recent letter, the OCC, on one hand, confirmed those letters. However, if you're going to do that, you need to get prior approval from your supervisory office, which on one hand makes sense, but it also suggests that, the effect of this is that on one hand, the OCC said, we're not saying you can never do it. You just need prior approval. I think it's fair to say that obtaining the prior approval will be a rigorous and demanding process. And remember, it's only the OCC that's issued this letter. The FDIC didn't do it. The Federal Reserve didn't do it. So they still haven't gone on record about these things. And it's also fair to surmise that until that supposed extra clarity comes out, according to the roadmap, a lot of the regulators are probably going to hold back on opining on anything or offering their non-objection to requests to, proceed with these activities. So it's a step forward, but we can also anticipate some continued delay in terms of clarity while the regulators continue their quote sprint. But it's really interesting to see the traditional banks wanting to get into crypto and blockchain because obviously it's here to stay. And, everyone, including the government, acknowledges that.
So, Margie, why don't you jump in with your thoughts here? What types of criminal cases are you seeing regulators and prosecutors bring?
Sure, thanks. And Peter, thank you very much for that. I think that what we can see just based on what Peter has said is this is a very complicated area. And you have overlapping regulators. You have regulators sometimes giving inconsistent guidance. As an example, the SEC has found that Bitcoin and Ethereum are not securities, but the CFTC has found that Bitcoin and Ethereum are commodities. So there's just a lot of confusion and complicated analyses that need to be done. So Peter's talked about money laundering and using Title 18 for money laundering. But what I'm seeing is a lot of crypto prosecutions brought under garden variety mail and wire fraud prosecutions, as well as securities fraud prosecutions. And so what are mail and wire fraud? Mail and wire fraud are very simple. It's use of the mail or the wires to defraud another by using false promises or misrepresentations. So all that has to happen is the mail or a wire, and that could include UPS, it include FedEx, it can include any of these common carriers, so long as there's some sort of, quote, interstate commerce. So if there is a view that there were false statements made in the marketing or sale of a crypto product, then the U.S. Attorney's Office, the Department of Justice, that you've been reading a lot lately, can bring a criminal prosecution. And they are doing that. And they are bringing criminal prosecutions for what we would call in the white-collar space, garden variety criminal conduct. And then you also have securities fraud charges, criminal securities fraud charges, which are brought, as well as civil securities fraud charges. So what's criminal securities fraud or civil securities fraud? It's fraud in connection with the purchase or sale of securities. And you could have a civil charge for the unregistered sale of securities. You can have criminal charges if there's fraud in connection with that. And so what's a security? The SEC has come out with a complicated test, which is called the Howey test, which goes back to a Supreme Court case from the 1940s, which talks about an analysis that needs to be done as to whether a particular product constitutes a security. The commissioners of the SEC have basically said that they have not seen an initial coin offering, which is the equivalent of an initial public offering. They have not seen an initial coin offering which isn't offering the sale of a security. So basically, unless a particular token is considered to be a utility token, which means that there's no profit to be derived from it, and don't just take this as the sole analysis, because lawyers really need to dig into these things before somebody engages in such a transaction. But if they conclude that something is not simply a utility token, there is a risk of civil actions taken by the SEC. And if they believe there was some fraud or misrepresentation in that sale, then you could find yourself as the subject of a criminal prosecution for securities fraud. So, my most significant takeaway from all of this is that just because it is this digital currency, just because it's not something that you can hold, does not mean that criminal and civil regulators are not going to take a look at what one is doing. So the absolute best takeaway that I hope somebody can take from this podcast, and I so enjoy joining my partners, Mike and Peter, on this podcast, I hope the best takeaway you can all take from this is complicated stuff. This is complicated stuff. And as lawyers, we much prefer to be giving the advice at the front end of a transaction, at the front end of somebody embarking on a crypto business, than having to help them unwind what they may have done or defend them in regulatory scrutiny on the transactions they've engaged in. So if there's one takeaway from this, please go to an accountant and go to an attorney that can help you make sure that what you are contemplating doing is set up lawfully and properly.
All right. Thank you very much, Peter and Margie, for the excellent discussion today.
Thanks again to Mike Robotti, Marjorie Peerce, and Peter Hardy. Make sure to visit our website, www.ballardspar.com, where you can find the latest news and guidance from our attorneys. Subscribe to the show in Apple Podcasts, Google Play, Spotify, or your favorite podcast platform. If you have any questions or suggestions for the show, please email podcast@ballardspar.com. Stay tuned for a new episode coming soon. Thank you for listening.